in the land transaction, verifying the information and details that have been provided to you, documenting your land transaction, and lastly, registering your interest. So now let's start with the pre-acquisition stage. You have decided to purchase a land or acquire a land in Ghana. The first thing you need to find out is environmental risk, because we have certain areas that are earthquake-prone areas or flood-prone areas. We are in the rainy season, and we all may have heard of flooding in some areas in Accra specifically. And before you even think of paying money for the land you are buying, it is very, very important to find out the area in which the land you are buying falls. You need to find out if it falls under an earthquake-prone area or a flood-prone area. It doesn't mean you cannot acquire land there at all, but what it means is that you need to do your due diligence by checking whether that particular plot of land would pose any risk to you. You need to be prepared for what you are entering into. After doing your environmental risk assessment and being sure that you can acquire land from any of these areas, then you need to do a site visit. You need to conduct a site visit. This is also very important. There are some buyers who skip this step and just go ahead and pay money without even going to see the plot that they are purchasing. Before you advance any money to any seller, try to conduct a site visit to the land you are buying. Physically inspect boundary corners in the presence of your seller. Let the seller point out the boundaries of their land and confirm the full extent and suitability of the land for what you intend to use it for. Also, when you conduct your site visits, try and engage owners or occupiers of neighboring lands for more details or information about the ownership and boundaries of the land. You can obtain information on any encumbrance that the neighbors may know about. This can be done in the absence of the seller of the land you are trying to acquire. When you do your site visits, it's also very important to take pictures to keep evidence of what you saw when you went to the land, because there are instances where people will tell you that it is a bare land that I'm selling to you. But upon your conducting your site visit, you would realize that there's a structure on the land, or there's a wall on the land, or there's any other property on the land. Take pictures for evidence. Now, after you have done your site visit and you are satisfied with the land you are going to buy, try and do negotiation and preliminary contracts for the transaction. This is a step that a lot of people also miss, because some people will just go and look at the land, or they will just go ahead and pay money because it is maybe a hot cake and they don't want another buyer to come for the land. But this preliminary contract, which we usually term as sale and purchase agreement, would put all the terms and conditions that you have negotiated and agreed upon with the seller down. And both of you will be bound by these terms and conditions. It also protects you, the seller, as well, because you are able to make sure that the buyer is committed to buying the land. This contract is a form of commitment for both parties. So when you are discussing your price, your payment terms, the duration for the interest you are acquiring, documents that you want to submit to the buyer, or you, the buyer, you are requesting from the seller, and even the time that you can take possession of the land. All these things have to go into this preliminary contract, which is your sale and purchase agreement. And make sure that in your negotiation, you are negotiating with the actual and rightful owner, not a middleman. Now, after you have this, your sale and purchase agreement, or even during negotiation for your sale and purchase agreement, you need to conduct your searches. You need to conduct your searches. Searches are extremely important in due diligence process of land acquisition. And the courts in Ghana have upheld official searches in various institutions to make sure that you, the purchaser, you are a prudent purchaser. So the first search we are talking about now is lands commission search. When you are acquiring a land, one important search you have to do is an official search at Lands Commission to verify ownership of the land. If someone comes to you and gives you a site plan and says that I own the land, this is my site plan, use that site plan to conduct a search, an official search at the Lands Commission. There is a practice that is coming up known as window search. It's usually an official search at the Lands Commission. It is very quick and it's usually conducted unofficially by some workers at Lands Commission, and you don't get official reports of the search that you conducted. People do these things as a fast way of determining whether their seller actually has title to the land. But it is not an advisable practice. It is not an advisable practice because, first of all, you don't have an official search report to use as evidence in future. And if any discrepancies come up later, you do not know who to hold responsible because it wasn't an official search from Lands Commission, and most of these workers will not own up when an issue comes up. So try and apply for an official search instead of doing this window search. Also, in addition to your Lands Commission search, it is important to do a court record search or court due diligence search. Sometimes some parcels of land may be the subject matter of disputes in court, or your seller or the owner of the land may have a lot of matters in court or may have a matter in court that can affect his ownership to the land. If someone has a case in court and unfortunately they lose the matter and they have to pay a judgment debt, their properties can be attached to satisfy the debt. And because of this, when you're acquiring a land from any landowner, one important search is the court registry search, where you will write a letter to the court registry where the land is located and ask whether the land that you are acquiring is the subject matter of any dispute in court or whether the landowner has a matter in court. These would help you to determine if anything is happening in court that can affect the title you are trying to acquire. In addition to court searches, you may also conduct searches at traditional councils or customary land secretariats, especially in respect to stool or skin lands and family lands. Now, another search that some people overlook is building permit verification. If you are acquiring a property that has a building on it already, a land that already has a building on it, or a land that, of course, you're intending to build something on it, you need to confirm whether you can get a valid building permit for the land. Sometimes these structures may not even have a valid building permit or may not be at locations that are required to have buildings there. You know, some people will build properties on waterways, and we know these things have been happening, and we've heard news on the news, some of these circumstances where people will build on waterways and the buildings have to be demolished later. So to avoid all these things, it is very prudent that you try and visit the Metropolitan municipal or district assemblies to find out whether the building has a valid building permit or the land is at a place where it shouldn't be developed. Now, after you have done all these searches and you maybe do not have any issue, you can now engage a licensed surveyor to go onto the land, obtain exact measurements of the land, and prepare a barcoded site plan for you. Please, it is important to note that you should not rely on the seller's site plan alone. Whatever site plan is given to you, you may use it to start your searches, but you need a licensed surveyor to go to the land, pick the measurements, and prepare a barcoded site plan for you. Barcoded site plans are the ones that have a code behind the site plan and are approved at the Lands Commission. And in Ghana, the law requires that it is only a licensed surveyor that can survey a land and prepare site plan. If the registered owner differs, if after your searches, if the registered owner differs or the site plan doesn't match what was presented to you, then at that stage, you need to halt your process and seek advice. You need to halt your process and seek advice. A site plan is presented to you. You have a licensed surveyor, pick the measurements, prepare a barcoded site plan for you, and you realize discrepancies between what the surveyor has presented and what was given to you. Or after your searches, you realize that the registered owner in the search results is different from the owner that was presented to you. Please halt your process and seek legal advice. Now, when you are done with all these searches, and after getting your barcoded site plan, then you can prepare your indenture. So from this process, you realize that a lot of us have been skipping so many steps that has to do with due diligence, because some people just go ahead and take the indenture without doing any search at all. After you are done with all your searches, you now have to prepare your indenture, which is your instrument of transfer. That is what you are going to use to show that the land has been transferred to you. An indenture may be a lease, it may be a sublease where the leasehold, the person having the leasehold interest is given a part of their interest, maybe a number of years out of their interest to another person. Or it may be an assignment where the leasehold interest is being given to you, like everything is transferred to you. Like the owner is transferring all their interest in the land to you. That is the assignment. So when your searches are done and your site plan is done, you can prepare this indenture. And the law requires, when you look at Section 33 of the Land Act, it requires that a conveyance shall only be prepared by a legal practitioner. So we need also to be very careful. If an indenture is given to you, you need to find out who prepared the indenture. Was it a legal practitioner? It was just anyone just preparing an indenture for you. You need to take note of that because that is the legal requirement. You would now submit copies of your indenture and the site plans to Lands Commission for registration. One thing to also note with the indenture is that under the Land Act, there is a requirement that an indenture should have at least one witness for both the buyer and the seller. This witness has to sign the document, provide their names and addresses. So every indenture should have witnesses. This is a legal requirement. Now, with your Lands Commission registration, you would submit your indenture, pay the prescribed fees. The documents will go to the Land Valuation Board for stamping. And after your document is stamped, it will now continue to go through all the registration processes as land commission. Now, please, when you are done with the due diligence search, you need to quickly register your land if there are any issues or red flags that are determined. Quickly register your land because it is very important to be the first in time when it comes to claiming title or disputes. Also, if you are acquiring land or throughout your land transaction, keep records. You need to have your receipts, you need to have your searches, you need to have your indenture, your sale and purchase agreement, everything recorded and kept safe for any future issues. When an issue comes up, all these documents will help you and it will determine whether you can win the issue, you can win the case or not, because it would show the steps you took as a prudent buyer to acquire the land. Now, I want to read this judgment from a case known as Kusi and Kusi versus Bonsu. It was held by the Supreme Court in 2010. And the court said that any person desirous of acquiring property ought to properly investigate the root of title of his vendor. In this case, which is the Kusi and Kusi case, there was no evidence of a prudent search conducted by the defendant. In the defendant's own pleadings, they said that they only inspected the title deeds of the assignor, coupled with a permit for construction, and were satisfied. The record does not show that they even sought professional advice before entering into the transaction. In our view, the steps they took are not adequate steps for a prudent purchaser of this particular property. Indeed, had they extended their search to the Lands Commission, Kumasi, the statutory body that kept official records of lands in Kumasi, they would have known that the land was encumbered. So this is what the court said in this case. Sometimes, in your view, your acquisition was genuine. You paid everything that you're supposed to pay. You had your indenture, you had your site plan. They even showed you their own title documents and everything was in order. So there's no problem. But the court is saying here that the defendant was not a prudent purchaser because they did not conduct search at the Lands Commission. So at the minimum, at least, just conduct your search at the Lands Commission and have records of the search. This can protect you so much in case the matter ends up in court. It will show that you were a diligent buyer. Now, let's note these couple of things when it comes to land acquisition. First of all, foreign participation. In Ghana, any agreement that is transferring freehold interest to a non-citizen is void. Also, for non-citizens, they can only hold leasehold interest up to 50 years at a time. Freehold interests that were more than 50 years and held by non-citizens before 1969 were all converted to 50-year leasehold, and the reversionary interest in these lands vest in the precedents in trust for Ghanaians. So, since 1969, no foreigner can hold leasehold interest beyond 50 years. This restriction even applies if a non-citizen marries or partners with a Ghanaian. If a company is a non-citizen or under the Land Act, a company is a non-citizen if more than 40% of the shares of the company are held by non-citizens. So we need to take note of this if you are a foreigner or your company is a foreign company and you are acquiring a land. Scrutinize your document and make sure that what is given to you complies with the law. If you are acquiring a land from married persons, you need to note that land that is acquired during marriage is deemed conveyed to both spouses unless otherwise stated. So if one spouse is named, that spouse holds the interest in trust for both unless a contrary intention appears. So jointly acquired land must be applied for in both names unless conveyance specifies otherwise. Single spouse application presumes that the applicant acts on behalf of both spouses. So now I think we can look at the questions that we have and try to address them. So that people can have a full understanding of what we are doing today.
Thank you very much, Alberta. We have a few questions for you, but we want to entreat all attendees. Kindly drop all your questions, your concerns in the chat box, and we'll attend to them. Like Ms. Chairman said, it is time for our Q&A session, and so we have a couple of questions. And the first question is, aside Lands Commission, are there any government agencies we need to deal with when buying land?
Yes, so during the presentation, I mentioned that you need to conduct your search at Lands Commission. But when you're acquiring a land, aside the Lands Commission, there is the courts, as I said earlier. There is also Customary Land Secretariat, which registers customary lands like stool lands and family lands. So in addition, and then also we have the collateral registry. Sometimes some people would apply for loans and they use their land as security. The security has to be registered at the collateral registry. So when you conduct your search at collateral registry, you'll be able to find out if the land you are buying has ever been used as security by your landowner or by your seller. So in addition to the Lands Commission, there are so many institutions, or there are other institutions that you can conduct your searches. All you have to deal with. All we have talked about is not exhaustive. So there are so many things that you can also do. There are so many things you can do: collateral registry, court, customary land secretariat. You also have your unofficial searches where you go to the land and speak to neighboring landowners and all that. So Lands Commission, yes, but in addition to Lands Commission, there are other institutions and other entities or individuals that you can also deal with when you're acquiring the land.
Thank you very much. We have another question from Felix. Felix says, how do you find out if a surveyor is licensed? How do you find out if a surveyor is licensed?
So licensed surveyors will have their license number that you can verify with institution that licenses surveyors. I mean, even if you go to Lands Commission, they can have records of all these licensed surveyors that they deal with. So you need to know their number, license number, and conduct your searches to verify the license number that they give to you. Ask for their license number. When you see site plans, sometimes these surveyors will stamp on it. They'll write their license number, they'll write their details. So with those details, can conduct your searches with Lands Commission, or you can conduct your searches with the surveyors. There's Licensed Surveyors Association of Ghana to find out whether they are licensed.
Okay, thank you very much. We have another question from Mr. Forson. Mr. Forson says, do you receive a site plan from the seller before the search and lands commission?
Yes.
And
So yes.
please go
So
ahead, and then I'll ask the second question, the second part of the question.
So usually when someone is selling a land to you, they mostly will present their site plan. Some of them will add their indenture to it, like their own title document to it. And these title documents usually has the site plan attached. But even without the indenture, you need to at least get the site plan. And with that site plan, you can start conducting your search at the Lands Commission. So the ideal thing is that request for your seller's title document, their indenture. And with that indenture, you would see where they acquired the land from. And you will start your searches with that. You will now go to their grantor. If it was a stool, go to the stool to verify whether indeed they acquired the land from the stool. If it was an individual, conduct searches, find out whether indeed your seller bought the land from that individual. And with the site plan, you will you would apply to Lands Commission and use the site plan to conduct the search at Lands Commission or any other institution that you may go to. So yes, your seller has to give you their indenture with the site plan attached.
Okay, so the second part of that question is payment or part payment of the land made before the acquisition of the land?
Okay, so I mentioned the sale and purchase agreement where it's a preliminary contract between the seller and the buyer. So based on this agreement, the parties may decide that you can give me part payments, and usually it is to lock down the interest you are trying to acquire and also show your commitment to actually buying the land. So some sellers would require that you pay part of the purchase price whilst you go ahead and do your searches or whilst you pay the rest in installments. So part payment is very common, and there's nothing wrong with it if you have to do part payment, but it is important that you have a contract that governs that. So your contract will say that after we sign this agreement, you have to pay maybe 20% or 40% or whatever, a percentage of the purchase price. Then after that, the remainder will be paid in installments over 6 months or whatever it is you agree. Then whilst you have that done, you will now go ahead and do your searches. So along the way, if anything happens, if any breach happens, then you can pause your process or you can ask for a refund of your amount that you paid.
Thank you very much. Thank you very much. That's very insightful. We have another question from Isaac, and Isaac says, what happens if I lose any of my documents through fire outbreak or any disaster?
Well, that's very unfortunate, but with this in mind, you need to always have a backup. For instance, if you bought the land, if you paid for the land and there is a receipt, usually receipts come in duplicate copies where the seller would have a copy with them. So with that one, you may get a copy from the seller. Or now we have digital gadgets where you can have copies of your receipts. So if you have a receipt, it's important to scan it or take a picture of it in case you lose the original copy. If it is Lands Commission searches, you can always go back for the official report again. You did a search at Lands Commission, they gave you search report, it's bent. You can go back for a copy of the search report again. If it is an agreement, you have copies of the agreement. If it's bent, you can take a copy from the other party, or, as I've already said, keep soft copies. So you need to have this in mind, and when you are keeping your records, have backups.
Thank you very much. We have another question from a foreigner. He says, I am a German citizen looking to acquire land in Ghana. Can a foreigner legally acquire land in Ghana, and are there any restrictions?
So yes, a foreigner can acquire land in Ghana. If you're a foreigner, you can acquire a leasehold interest in Ghana. As I earlier said, from 1969, no one can acquire freehold interest. So the interest you can acquire is a leasehold interest in the land, or coming down from leasehold interest. So a foreigner can acquire a leasehold interest where you have a specific duration. And in Ghana, you can only acquire 50 years at a time. 50 years at a time. So if you see your seller, the seller will say, I'm giving the land to you for 60 years. You should know you can't get that. It's only 50 years. And also, Ghanaians, there are circumstances where Ghanaians can have automatic renewal of their leasehold interest, but foreigners do not have automatic renewal. If you want renewal, it has to be specifically stated in your agreement. So you have to take note of these things as a foreigner.
Thank you very much. That's very insightful. So in essence, what you are saying is that if anyone comes and says that they can give you 99 years as a foreigner, they cannot, right?
No. Yes, that's right.
Okay. All right. Thank you very much. Thank you. We have another question from Emmanuel. Emmanuel says, can you confirm, can a Ghanaian hold freehold lease as a private individual?
Okay, so we do not have freehold lease. Freehold interest is different from a lease. So I earlier mentioned that freehold interest is acquired perpetually, is indefinite. Okay, and when someone acquires freehold, it has no obligation to anyone. But in Ghana, as it stands now, no one can acquire freehold interest. The law does not allow anyone in Ghana to acquire freehold interest, whether you're a citizen or not. Then we have lease. Lease is for a specific duration. So you can acquire lease. Lease will tell you that you have the land for 40 years, for 20 years, for 30 years, for 99 years, which is the most common. So that is a lease. And when you acquire the lease, you can also sublet it to someone, which is what we call the sublease. So for instance, you have 99 years, then you give 50 years out of the 99 to someone. You have carved another lease out of your lease, which is the sublease. You can also assign all the interest you have. So you have 99 years, you've used the land for 20 years. You can transfer the remainder, everything, all your interests in it to someone else, and that is an assignment. So freehold is different from lease.
Okay, so for further clarification, if I, for instance, I hold a freehold interest in a land and I want to transfer my interest or my title to somebody else, can I do that?
Yes, so if you have a freehold interest, so those who had freehold interest before it was banned, they can transfer the leasehold interest to someone else. Okay, so they can transfer the leasehold interest to another person.
And that person now has freehold.
So, okay, so for instance, because there was a situation where someone died, he had a freehold interest and he willed it to his children. Okay, so now the children will be the freehold interest holders. So in essence, it wasn't a new something that has been created. It's just what he had that was transferred to his children. So yes, if someone had the freehold interest, they can transfer it to someone else, like the full freehold to someone else. But as it stands now, those two can carve a new freehold interest to someone. I don't know whether this is clearer.
It is. It's much clearer. Thank you very much. Thank you. We have our final question, and this is from Bless. Bless says, how much does a title certificate cost?
There isn't a specific price for a title certificate. What happens is that you will pay statutory fees at Lands Commission to register your land. And the land registration has different steps that you have to go through at the Lands Commission. If you submit your indenture to the Lands Commission, they would start with searches, you will do stamping, it will go to the different divisions of Lands Commission, and all these steps have amounts that you have to pay before finally, when it gets the land title registry, you would pay whatever you have to pay there to get your land title certificate. I cannot tell you the exact fee for land title certificate, but you can always determine the fee that's attached to it at the Lands Commission. And mind you, some of these fees are subject to review. So you need to always confirm the current fee that you have to pay at the various institutions, various departments at Lands Commission.
Okay, thank you very much. So I want to address Mr. James Kofi. If you can please ask your question again. I think it got lost somewhere in the chat. So if you can please quickly ask your question again, then we can address it quickly. I think the discussion on the freehold is quite an interesting one because we are getting some further questions on the freehold. So Felix says, if person A has a freehold and sell it to someone, will that new person what will that new person hold? Or is it a 99 years lease? I don't know if the question is a bit confusing, but I think we get the general idea.
So is he trying to say that can I sell all my freehold or I have to sell leasehold interest? Is that what you're trying to say?
Yes, basically, I think that is what he's asking.
Okay, all right. So it's possible to sell your freehold interest because the freehold interest already exists. You already have that freehold interest. It's possible to sell the freehold interest, but most of the times you would find people selling a part of their freehold, selling a part, as in like giving a leasehold interest instead of the freehold interest. Because if you are giving all the freehold interest, that basically means that you have no title to the land. You have no reversionary interest in the land anymore. You have no reversionary interest in the land. It's gone forever. So freehold it's even quite uncommon now. And as I said, the recent one I saw was actually someone who willed his interest to his children. So yes, it's possible to sell all your interest in land. That's why I said when it comes to assignment. If you are selling all your interest in your land, it means you are giving everything to someone. It's possible. But the most common you find is leasehold interest.
Okay, thank you. Understood. Thank you very much. So James said, what about family lands that are fresh? I mean, no site plan, no layout, nothing. How should one go about such a purchase?
No layout, as in no site plan. Okay, bare land. Okay, so yes, so yeah, so it's very important to also, I mean, for us to discuss this thing because it brings up boundary disputes. So sometimes you would see some families, they have a land, they haven't even properly demarcated the land and it hasn't been registered, nothing of that sort. When you get such a land, as I said, you need to take your surveyor there to pick the actual measurements. First of all, the actual owners have to point out the boundaries to you. If you are dealing with a family, make sure the family head is available, elders of the family are available. Go with them, let them show you the actual boundaries of their land. Then go with the surveyor to pick the land and have the survey registered. They have to map it at the survey and mapping division. This site plan or whatever to be prepared to show the boundaries have to be registered. In that case, there will be record of this land that has not yet been demarcated at the Lands Commission for any future buyer or any person who would subsequently conduct searches at Lands Commission. So don't just rely on what they will show to you that this is our part of the land, and then you go ahead and buy it, especially with such new lands that are yet to be demarcated and all that. Make sure you pick the measurements, have it registered at the Lands Commission.
Okay, thank you. And then we have another question from Emmanuel Porte. Emmanuel said, what happens at the end of the lease? Does the buyer need to repurchase the land at the full price?
So the law provides that Ghanaians can have renewal. You are entitled to a renewal. You are entitled to renewal subject to agreement between the seller and the buyer. So you can get a renewal, but the price is subject to agreement. It is not specific that you would have to pay the full price or you have to pay a particular amount of money. It all depends on the agreement that will be reached between the landowner and the buyer. So at the end of your lease, you can get a renewal, but the terms of the renewal and the payment will be subject to agreement. Some people may just say, some stools or whatever will just say pay an amount of money that may be lesser. But we all know that if you have stayed on the land for maybe 20 years or 30 years, definitely after that 30 years, you won't get the same amount that was paid 20 years ago or 30 years ago. And sometimes even the stool, the one who is the traditional leader, may have changed. So some of the terms too may change. So all these things, we should have that at the back of our minds that the renewal may not be maybe in quotes as simple as maybe you would think, but it's all based on negotiation and dealing with them, because if you stayed on the land for a number of years, they may already know you and all that. So it may not also be a problem asking for renewal, but for the amount, it's based on agreements.
Okay, well understood. I want to address our attendees. Unfortunately, we will not be able to take all your questions. We know that land issues is a very hot topic, but unfortunately, our time is very limited, and so we'll not be able to take all your questions. We will encourage you to send your questions to an email address will be sent, will be scrolled down on the screen for you to send any questions that you may want, and your questions will be addressed. But we have one final question for our panelists, and it says, when you do a search at the Lands Commission regarding a family land, does the search specify who the right person is to deal with on behalf of the family?
Yes, yes. The search would show the family involved, like if it is whatever the name of the family is, you would have details of whoever applied for registration of the land. A detail, that's what I'm saying, that you have to do an official land search, because a detailed land search would have so many details, you'll be surprised. You can even have roots of title. If it is aside from family lands or whatever, you would have root of title. Sometimes how the person got the land. If they got it from a family, it would have details of the transaction. Maybe it was between so and so as the family head of so and so and this person. The agreement will be noted there. Then it came to this other landowner. So a detailed land search would give you details of who you have to specifically deal with.
Thank you. Thank you very much. So all too soon, we've come to the end of our webinar. We want to give our resource person the final word before we sign out. Any final words for us?
Okay, so finally, what I would say is that we need to be very careful when we are trying to acquire land in Ghana, or even as sellers when we are selling our land, because of all the risk that come with land acquisition in Ghana. And let us not ever skip due diligence process, because no matter where you end up, it is due diligence that will save you from losing everything that you paid for. Some people are quite apprehensive about due diligence because it takes a long time. But if you have enough money to pay over 200,000 Ghana cedis for a land, then you should also have that time and the minimum amount to conduct your due diligence and ensure that you don't lose all that in future. So please, we are available. If you have any question, as has earlier been said, you can ask us and we can address them later. Thank you so much for joining today's webinar.
Thank you very, very much. This has been a very insightful and educative webinar. Before we finally sign out, we want to say a few thank yous. We want to say thank you to Firmus Advisory Limited for giving us the platform to bring you this webinar. We also want to say a very big thank you to our resource person, Ms. Alberta Tremi, Esquire. Thank you so much. This webinar has been very educative. And also thank you to our attendees. Of course, without you, this would not have been possible. Thank you so much for making time to join us and to listen to whatever we have for you today. Like we earlier said, any questions you may have, you can please send them to our email addresses and they will be addressed. Thank you so much. My name is Lucille Nayabole-Kashabe, and I've been your moderator for today's session. Thank you and have a blessed day. Bye-bye. And they will be addressed. Thank you so much. My name is Lucille Nayabole-Kashabe, and I've been your
Even the partnership has solid legal foundation. Corporate governance is equally important.
He's talking about oh, okay.
But then companies have at least two directors, a shareholder, an auditor, and a company secretary. The shareholding structure must be clearly defined, including the limits
Chief, the recording. You recorded it
of
for me.
shareholding.
Okay.
Parents of my distributed fees, maintaining accurate records of resolution.
So once you click on stop recording, it automatically saves, right? Onto the Zoom, this one.
When you end,
When starting a company in Ghana,
that's what you
legal due diligence is how to ensure compliance and mitigate risk. Firstly, It is crucial for a foreign investor and to have the insurance drafted when entering into partnership and this ensures legal clarity and safeguards and protects the foreign investor. Ghana's legal system has specific requirements that may not be familiar to the foreign branches. It is important for the contract analyst to protect the investor's interests and clearly define each party's rights. This prevents disputes, safeguards investment, and ensures compliance with Ghanaian regulations, giving the partnership solid legal foundations. Corporate governance is equally important. The Companies Act 992 mandates companies to have two directors, a shareholder, and auditor in the company secretary. The shareholding structure has been clearly defined, including the right to inform of shareholding, regular board members, are key to ensuring and running a company that is transparent and compliant. Once you enter a company in Ghana, legal due diligence is critical to ensure compliance and to mitigate risk. Firstly, it is crucial for the company to have the contracts drafted when entering into partnership activities. This ensures legal clarity and safeguards and protects the foreign investor. Ghana's legal system has specific requirements and nuances that may not be familiar to the foreign parties. It is important for the contract and requirements to protect the investor's interests and clearly define each party's rights. This prevents disputes, safeguards investment, and ensures compliance with Ghanaian regulations, giving the partnership solid legal foundation. Corporate governance is equally important. The Companies Act 992 mandates companies to have at least two directors, a shareholder, an auditor, and a company secretary. The shareholding structure must be clearly defined, including the right to of shareholding, regular board meetings, parents to fiduciary duties, and maintaining accurate records and are key to ensuring and running a company that is transparent and compliant. When starting a company in Ghana, legal due diligence is critical to ensure compliance and engagement. Firstly, it is crucial for a foreign company to have a contract drafted when entering into partnership. This ensures legal clarity and safeguards and protects the foreign investor. Ghana's legal system has specific requirements and nuances that may not be familiar to the foreign parties. That is important for the contract aligned with requirements, protect the investor's interests, and clearly defines each party's rights and responsibilities. This prevents disputes, safeguards investment, and ensures compliance with Ghanaian regulations, giving the partnership solid legal foundations. Corporate governance is equally important. The Companies Act 992 mandates companies to have two directors, a shareholder, an auditor, and a company secretary. The shareholding structure must be clearly defined, including the right to of shareholding, regular board, parents to fiduciary duties, and maintaining accurate records of transaction are key to ensuring and running a company that is transparent and compliant. Once you have a company and legal due diligence is critical to ensure compliance and compliance with. Firstly, it is crucial for the foreign investor to have a transparent when entering into partnership. This ensures legal clarity and safeguards and protects the foreign investor. Ghana's legal system has specific requirements and nuances that may not be familiar to the foreign parties. It is important for the contract aligned with requirements, protect the investor's interests, and clearly defines each party's rights and responsibilities. This prevents safeguards investment and ensures compliance with Ghanaian regulations, even the financial solid legal foundations. Corporate governance is equally important. The Companies Act outlines mandates companies to have at least 2 directors, a shareholder, and auditing independent. The shareholder structure must be clearly defined, including the right of shareholding, regular boarding, parents of fiduciary duties, accurate records of expression, and key to bring and applying a company that is once the actual company is done, due diligence has how to get the demands of claims received or sleep discrimination. Both entry and partnership. This ensures legal rights and safeguards and protects the foreign investor. Ghana's legal system has the power to join. May not be familiar to the foreign partners. It is important for the aligned protect the investors' interests and clearly define each partner's rights and responsibilities. As an investors, safeguards the person and ensures that Ghanaian regulations, even the partnership has solid legal foundation. Corporate governance is equally important.